Good evening. We're doing things just a little bit differently. As you can see here, we are live in downtown Houston, and behind me is a pretty important building, at least this week and perhaps for the next 2 months. It's where the A.J. Armstrong trial is going to be going on. Number 3 trial. Let's do the introductions real quickly. I'm a reporter, Joel Eisenbaum. Brian Weiss, our legal analyst, is right next to me. And excellent reporter Rowan Belugan is next to him. Let's get right into it. It's because a lot was going on this very first day. We're in the jury selection process, which the judge says could take a month.
Yeah.
And the pacing seems, I don't know, I guess they were going through it sort of quickly today, but they've got a lot to do. Before we get to that, Brian, and I know you're chomping at the bit, I was interested in something that happened right at the beginning of the day when we were in the courtroom, and Rick DeToto, the defense attorney, the lead seat for the defense team, got up and he had a problem with where the state was sitting, where the DA's office, where some of their members were sitting, or one in particular. What was that about, Rowan?
So there was one person, if I may get up here really quickly to kind of show it here. So what we'll see, this is the state, the defense here. And there is one person with the state sitting right over there.
She was very close.
Very close in earshot of where the defense would have.
Because A.J. Armstrong's what, right here?
Right there. That's exactly where A.J.'s sitting. And so that was the issue DeToto had, saying that they wouldn't be able to speak in private without the possibility of this in person listening in on it to it. So there's a whole thing about that. Eventually, she did have to move on over. And
she gave some resistance, though.
There was. She didn't want to move because they didn't want them to have their back turned to the potential
That's what they're worried
jurors.
about, which you don't want to have, I imagine. You don't want your back facing the jury, because they're using the jury box because they have so many people stuffed into that courtroom during this jury panel trying to whittle it down process.
I mean, make no mistake, guys. A courtroom is as territorial as an NBA court during the finals or Game 7 of the series in MLB. Everybody wants to stake out their territory. And in a situation like this, you want to be able to have that comfort space. You want to be able to talk to your client without somebody overhearing something that could be consequential sometime down the road.
Let's dispense real quickly with a little bit of old business, if you can call it old, but it's from last week. We saw a flurry of motions from really both sides. It was kicked off by DeToto and the defense team. Tell us a little bit about that, Brian. What was that about, and what was the resolution to it?
Well, I think the motion of the day was the motion that the defense filed, essentially calling out the prosecution because they didn't disclose that an alternate juror had allegedly dated a member of the DA's office. And when you think about it at first blush, you're thinking that's a farce of a mockery of an outrage of an injustice.
Right.
And you realize that it was essentially, and this is a legal term we use, Bush League. I've known Rick DeToto for 2 decades. He's a good lawyer. I had the privilege of trying the Ashley Benton case with him. But Rick's discovered, as those of us who are involved in high-profile cases, that cameras and live trucks and microphones are intoxicating. And if you find yourself in a position where you're saying more than you should, you're going to find yourself in a position where the defense did, filing a frivolous motion that really was a lot of sound and fury about nothing.
Judge Kelly Johnson, she jumped on that quickly last week. I think she made a ruling with like an hour or two to go. But we saw more motions after that. The one that I was interested as a journalist was the move to seal any pending motions. What became of that?
Well, the judge denied that motion, saying it wouldn't happen. Essentially, that motion itself was saying that before it was open to the public, the judge wanted to say yay or nay to it. And she said, no, we're not going to do that. We're just going to keep it as is. But what today's most focus was about today was on that jury selection. As we mentioned, 74 people really filled in the 19th floor.
Should have been 75.
Should have been 75, but we know one person didn't show. We don't know what happened with that person, but they proceeded on without them, 74 in total today. And we know that they had filled out some questionnaires. From the questionnaires, they had lunch. And from the questionnaire itself, after that, what happened was the judge asked all the jurors, hey, do you know any of the attorneys here? Do you know the suspect here? They said no. Then the judge read the indictment, where the judge said something to the effect of, Antonio Armstrong Jr. is accused of killing Don and Antonio Sr. And that's when 24 people said, wait a minute, I remember this case.
Now, Brian, does that immediately exclude these people from being on the jury?
No, not at all. Look, we don't expect jurors to live in a vacuum. What are they going to live on Mars? Absolutely not. In a high-profile case, as a potential juror, guys, it's not what you know, what you heard, what you read. It's what you think. It's whether or not you can take any of those opinions you may have formed, your take, and put it out of your mind and decide the case solely on the law and the evidence. And we've seen so many high-profile cases in this building behind us over the last decade or so. And what we realize ultimately is that there are some people who don't watch TV, read the papers, or engage in social media research. But at the end of the day, you're going to find people who may even have an opinion about the case. But if you can set that aside, unless you've formed an opinion as to this defendant's guilt or innocence, you're good to go.
Yeah, that's it. That's the goal here, right? Is to find a jury that can be impartial and make decisions based on the facts of the case, right?
And the law that Judge Kelly Johnson will give them at the end of the evidence and what we call the court's charge, the instructions that gives these 12 people and the alternates all they need to know.
And we know there were a few people in the jury selection that they did say they had an opinion to believe. There was one person who said something to the effect of that they believe that they remember that AJ was arrested, and they thought that if you're arrested, they said this quote, a lot of time, energy went into the investigation. And then the judge then asked, well, would you be able to have an open opinion? They said he was unsure if they were guilty or not guilty, talking about AJ there.
I would say at that point, they are probably going to be home in time to watch Houston Life, guys.
Right. And they did dismiss. They did a fair amount of dismissing today, right? What was the total number?
I think
do we
it was
know?
39, I believe. But I think 39 people were dismissed
So
today.
they've cut that initial panel, I guess you'd call it, in half already. But they're supposed to be looking at they're going to bring in an entirely new panel of people, I understand it, on Monday.
Yeah, on Monday we'll start this whole process again, where another panel of about 75 jurors will come in and do this whole process again. That's on Monday, but tomorrow we'll start with that smaller group of people when it's, I'm going to butcher it, voir dire.
Very good.
Good, close enough.
East Texas. Anybody that says voir dire, I'm going to get him after we shoot.
So let's talk about that for a second. How is this trial different? I mean, this is usually reserved for a death penalty type case, right?
This is an outlier. And the reason why we find ourselves with individual voir dire is because it was a compromise hashed out between Judge Kelly Johnson, the prosecution, and the defense. Judge Kelly Johnson was ready to take this show on the road, and she probably could have. But rather than do that, she agreed to individually examine each juror over the course of the next month and change. And that's so the court and the parties can determine whether or not this firestorm of publicity will affect anyone's ability as a potential juror to be fair and impartial. And that's why individual voir dire is going to make jury selection in this case, unlike your typical no-test DWI, a marathon, not a sprint.
How many jurors will they need? I mean, you need the 12, and then how many alternates? We haven't gotten any indication yet from the judge.
I'd say it's a question of what Kelly Johnson thinks will put her in a position where she doesn't run out of jurors.
Right.
If for some reason somebody has a car wreck, somebody gets sick, somebody has a baby. I'm thinking at least 6, maybe more in a case of this magnitude. You always want to err on the side of inclusion when it comes time to picking alternate jurors.
So that's between 15, 18 people who are going to be essentially donating 2, maybe more months of their lives to this trial.
It is a sacrifice. It's not really what we expect. When any of us get that jury selection notice in the mail, that's when I become popular. My friends will call me up, including people at Channel 2, and say, what can I do to get off jury selection? I'm like,
Not me. I have not made that.
I am not a lawyer for purposes of this. Look, it's a sacrifice we expect people to make, but it's one that the system ultimately depends on, because any defendant accused of any offense is entitled to 2 things: a fair trial and a reliable result.
Hey Brian, real quick, what is your ideal juror?
Well, it depends.
The producer asking a question off screen.
Look at that, right on the air. Like, depending on whether or not I'm the prosecutor or defense.
What was the question?
What's his ideal juror?
What's your ideal juror?
So if I'm John Jordan and I'm Ryan Trask and I'm a prosecutor.
Can you use this part?
Sure, absolutely. I want somebody.
You want to switch seats?
No, I'm fine.
Okay.
With a gut, somebody who's going to be able to look at this case, not from 35,000 feet, not with 1,000 different nuances, but to just look at this case and the evidence and suggest that when it comes time to determine who committed this offense beyond a reasonable doubt, it's somebody who was in the house, somebody with motive and opportunity, and that's the defendant. Somebody who I don't want as a prosecutor, let me see if I can do this. M-A-M-A-B-E-A-R. I don't want a mama bear. I don't want somebody who doesn't.
Define mama bear.
Mama bear is somebody who can't wrap their head around what most of us can't. The fact that this defendant, the flesh and blood of the people whom he allegedly killed, could execute those people while they lay sleeping. Now, if I'm somebody on the defense side, who do I want? I want somebody who is a free thinker. Somebody, let me see if I can write free thinker.
There should be a little line of demarcation here, right? Because
Yep.
this is the state and this is defense.
I want somebody who's going to be able to look past the obvious. Somebody in a situation who's going to be able to render a verdict that may not be popular, but in their estimation is going to be right.
Makes sense. We had talked about earlier of it possibly being a grandma type that they might like because, I mean, he has big support from his own family, at least most of the family members I've seen. And grandma's been on TV a couple of times. Maybe that's somebody that would identify with an older set, or am I just making this up?
No, I don't think you're making it up for once. I mean, it's a situation where the grandparents have been his strongest supporters. That, to me, in addition to this young man, who's no longer a young man, being on bond, is the ultimate home court advantage in any criminal case. Because if you have to rely on communicating with your client while they're in custody, believe me, you're going to be a 16 seed. The odds of you walking out of the courtroom with your lawyers instead of with the bailiffs and cuffs is very, very small indeed.
And the grandparents were there again today.
Very beginning of this marathon, guys, and it starts bright and early tomorrow. The judge has moved up the timeline in terms of the start time, I think, to 8:30, so she's got a lot planned. For now, we're live downtown. We're going to send it back to you guys who have much more news right after this break. TV?
We're back.
All right, so we're picking this up on 2+. It's hard for me to follow. We have so many platforms on it. But we're talking about A.J. Armstrong, his third trial, just to bring everybody up to speed, who's on the 2+ platform and channel, and it's a big first day. It's jury selection. So to pick up our conversation, and that's exactly what I want to do, are these dueling motions that we saw. We talked about it a little bit at the beginning of our segment for the TV show, but I mean, to me, it does seem like there's a little bit of divisiveness between the DA's camp and the defense attorneys. Am I making that up?
Not at all. Believe me, from the very beginning of this case, there has been bad blood between the defense team and the prosecution. So much so that Dane Schiller, who is one of the many PR flacks that the DA's office employs, made a comment online that Rick DeToto took offense to, and Rick turned around and sued him. And they went through pre-trial.
Rick sued Dane?
He absolutely did.
Did he really?
He, from as the good Lord is my witness, and it got as nasty as a bar fight in West Texas on a Friday night. And this was a case that ultimately was settled, but that's what we're looking at. And when Rick DeToto turned around and filed, again, this quote, Bush League motion, those are my quotes, not anybody else's, I was disappointed. Rick DeToto's a good lawyer. I've known him for a long time. He's better than that.
What is he trying? So, of course, I take no side either as a journalist, as I'm sure Real One doesn't either, but what is he trying to accomplish? A delay?
I don't think it was anything more than just trying to cast the prosecutors in a bad light. Look, this is a morality tale, and so often jurors on some level decide on the law and the facts, which is what I read on the internet they really ought to do. But sometimes, as Mark Twain said, it's a situation where the jurors figure out who has the better lawyer. And in that situation, you want to be liked. And whether or not Rick DeToto is trying to cast an alternative narrative about Rick and the defense being good guys and the prosecutors being guys that have sharp elbows and hitting the clinch, you never really know. I thought it was unnecessary. I thought it was gratuitous. Rick's the kind of lawyer that doesn't need to engage in that kind of nonsense.
Okay, this is all noted, and this is Brian's opinion. Let's get back real quickly to the jury selection process. Yeah. Real One, are you going to be in there bright and early tomorrow morning?
Be in there at 8 o'clock.
So what is the scene for people who can't be inside of the courtroom? I mean, it is filled to the gills when the jury panel is in there, right?
It was packed. We had to kind of fight to get a reporter in the room. It was all filled up. They were even using the jury box there as well to fill all of these potential jurors there. And at that point, it's just them in there for a long time, taking in the questionnaire, they're being asked a ton of questions. And then we get a number of things. Let me tell you here that they basically told them, clear your schedule for all of May. Clear schedule for all
That's
of
a
May.
big ask. I mean, you're obligated, I guess. You're obligated
It's your civic duty.
As a civic duty, exactly. But boy, I mean, moms, dads, everyone else living their lives. It's just basically you're going to be doing this the next month or two. That's,
You know, again, this is not what you envisioned when you got that jury selection notice in the mail. You're hoping it's a no-test DWI that's over in a day and a half. You're hoping it's a slip and fall that they can try in this building to my left. This is a case involving real people, and futures are on the line. And we ask that anybody in this county who gets that notice comes down and does the right thing for the right reason at the right time, guys.
yeah.
What are you expecting through all of this? We obviously have a month of when we're trying to figure out who will be seated, and then testimony should begin June 5th. What are you expecting from then until?
Let me just say this about the concept of jury selection. It's kind of like government intelligence or jumbo shrimp. It's really a disconnect. We're not talking about jury selection. We're talking about jury elimination. We're talking about you as a prosecutor or you as a defense attorney trying to eliminate those people who you think are not going to be good news for your case.
Toto did a shuffle this morning. What is that?
That is something that is unique in Texas law. Let's just use a very simple example. In a no-test DWI case, if they bring in a panel of 30 to seat 6 jurors and 1 alternate, they are lined up, numbers 1 through 30, in the order in which they came to the jury selection room. They each have a card that has an individual number on it. If you as a defense lawyer, as a prosecutor, don't like the people we call in the strike zone, those are the people that are likely to be on this jury unless they're challenged for cause or struck for no reason.
So if you're an early, this is sort of bonus knowledge for potential jurors. If your number's low, you're more likely to be on a jury?
It's if you are in the first group of people in the first 2 benches, and again, we're going to use that no-test DWI as a hypothetical, in the first 12 people, you are going to likely be on that jury. So you're in a particular order, let's just say 1 through 30. If either lawyer doesn't like the way they're lined up, and they can see as they're lined up for any reason at all, you can go, yo, time out, I want to shuffle. They take, excuse me, the bailiff will literally take those cards and shuffle them.
Saw that happen.
Oh, wow.
And all of a sudden, the next thing we know, take 2, we're rolling, you're going to see jurors in different positions. And that is something that is unique to Texas jurisprudence.
Each side gets a shuffle shot?
No, you only get one, so it's
But each side gets one?
Nope, there's only one shuffle.
Oh, really?
Throughout the entire time.
And either one can request?
It's whoever asks first. And so if you want to shuffle, congratulations, you're going to get it. And in a case of this magnitude, or in your typical murder case where you may have a jury of 60 and you request a shuffle, you are going to get, this is another legal expression we use, guys, the stink eye from the judge, the bailiff, the court reporter, and anybody who's going to be responsible for reseating those jurors.
Can we talk about something real quickly, maybe our last topic, but I want to talk about how much time has gone by since this crime was committed by whomever committed it. That was 2016. Nobody had ever heard of COVID before. I mean, it was a different world, really. And this kid at 16 years old who's accused of this crime is no longer a 16-year-old kid. He's a 23-year-old married man with his own child. Does any of this stuff, that maybe the passage of time or that he's an adult now with his own child, do these things play factors in jurors' minds in terms of where they're going with a verdict, or facts are facts and you make your decisions?
Joel, in a perfect world, it's not supposed to make any difference. You are supposed to be judged in any case based on the law and the facts. But in a situation like this, we're all human. And I think that if A.J. Armstrong was going to trial as a 17-year-old as opposed to a 22 or 23-year-old, there is obviously that sympathy that you may not have for the A.J. Armstrong who walks into court today as a dad and a father. Guys?
Oh yeah, we have one other special. Anna is holding up gigantic cue card since I can't look, since I can hardly see. But we actually have sound from, is that from the second trial? So this is 2022, and this is a juror who thought, I believe, that the defense team was kind of trying to lead people a red herring sort of path. Let's listen to them.
I feel everyone was more so focused on the defense's distractions, how I want to put it, as far as Josh being a factor and the garage door having some sort of access from outside people. So I felt there was so much attention on those factors that everyone just wasn't focusing on the actual facts. And they were just creating their own scenarios to where eventually more people were like, oh, okay, I can see why you would have reasonable doubt. And that's where it went from 6-6 to 8-4. And in my position, I'm still trying to, even at that point, I'm going back and forth like, okay, well, am I missing something? So I think it was just a bunch of back and forth and confusing each other. Because at one point, everyone said, oh, we know he did it. We know he's not innocent, but we still have doubt. So I think it was just a bunch of confusion and people overthinking it and not really wanting to accept it for what it is.
It really is a critical process in terms of who you get on that jury, I guess, right?
It is the most critical portion of the trial. Trials are won or lost well before the first witness ever hits the witness stand, final arguments, or a verdict. And it's clear that you may not be able to win a case during jury selection, but I guarantee you guys, you can certainly lose it. And I really think that's what the state's mindset is about what happened with trial number 2. They found out a number of things about the jury that they ultimately selected / eliminated. And if they could go back in time, they would have. But I think they learned valuable lessons from trial 2 that they're going to bring to bear when it comes to picking a jury in trial 3.
Things really turned around that second trial, right? What are the numbers on that?
It was in the second trial, 8 not guilty, 4 guilty. In the first, it was in reverse. So that was just very interesting.
What kind of indicator is that to you? Is that an indicator?
On so many levels, you want to think that it is. Jurors are like snowflakes. No two are alike. And you don't know what's going to happen from the time that a juror answers your questions during jury selection until the time they go back in the jury room and it's time to make a decision about whether or not this young man goes to prison and doesn't get out. So all you can do is hope that your preparation pays off. In a situation like this, I know that these 2 prosecutors who I just spoke with before we came on the air are dedicated civil servants. They are prosecuting this case for a 3rd time, which I think our viewers recognize is itself an outlier, because they believe that a rational Harris County juror, hearing all of the evidence, is going to find this young man guilty beyond a reasonable doubt.
Speaking of jurors, we have one more soundbite we want to hear from, although I can't remember what this particular juror has to say. But you're going to find out right now.
We were not supposed to talk about it when we're alternates, but, when we get in there and we look at each other all dead in the eye, we all know what each other thinks, and we all know that there's nothing that was going to change our mind. There was just too many things that didn't make sense, that added up, from the 911 call, that was the big one. You hear a door creak opened. My fellow alternate also wrote that down in her notes, and we talked to each other about it, but I never had anybody else mention that. And then if there was a masked man that they, mentioned later on in that interview, why was there no concern for going down the stairs? Why was there no concern for, oh, well, what if he's still in the house? Why? There was no concern like, oh, are you sure it's okay? Are you sure it's safe for me to go down there? None of that.
Whether you're the prosecution or the defense, it's important to sort of thread a storyline there, tell a cohesive story, because things can get caught in a juror's mind that can send things the other direction, right?
Absolutely. And not to name drop, but Robert Hirschhorn, who is the guru of jury selection, who I have had the privilege of knowing for almost 4 decades, likes to tell audiences when he lectures that if you can't frame a narrative about your theory of the case and put it on the back of your business card, you haven't thought it out. You need to come up with a narrative that tells potential jurors what this case is all about. And unless and until you've thought it through, you're going to be in big, big trouble.
Don't you have to have an alternate suspect, though, that way?
You don't have to.
Does he? Kind of the brother?
That's what the defense has been arguing for both trials. They're arguing that the brother is the other person, saying that he has, he knows the passcode to get into the home, so that's why the alarm may not have gone off. And that's what they're really focusing on. They just want to put that doubt in the juror's mind, and that's really all they need. Just put it on someone else, right?
Absolutely. Look, at the end of the day, for those of us who didn't sleep through government class, recognize that the state needs to run the table. They need to go 12 for 12. All the defense needs is one. All they need is reasonable doubt, doubt based upon reason, and everybody goes home yet again.
Rowan, any final notes for us as we head into day 2? This is just the first day. This is what has happened the first day. And this is just trying to pick a jury.
This is day 1. It's going to be a lot more to come here on the bench. June 5th, things we expect to start. They said take off basically June, prepare that. And I think we're in for an interesting trial.
If you are a juror and you're like, man, I can't spend 2 months doing this. I don't want to give people a recipe of how to get out of a jury service. But are there reasonable excuses that...
Absolutely. They're what we call hardship explanations. I think the most popular, the most common, I've got prepaid tickets to go to Cozumel.
Does that get it?
It absolutely does.
It does.
Usually, I mean, unless the judge is hard-hearted. Look, Judge Kelly Johnson, this is not her first rodeo. Mm-hmm. She's not going to be, that judge who makes people come to court when they've got prepaid tickets, or when their son or daughter may be graduating, when somebody's getting ready to have a baby. I think the other more common explanations and excuses are you're a caretaker for an elderly individual, or you're a sole parent. But by and large, you better have a pretty good excuse if you think that you're going to walk out of there in time again to go home and watch Houston Life, guys.
I'll tell you, someone said they have...
Life.
Yeah.
Someone says they have a cruise that they're going to, so they can't do that, and they're visiting mom in India. That's what some of the jurors said. And 31 of the 74 said they have plans in May, June, or July.
Well, I think we've all got plans for May, June, and July.
3 months. You're probably going to have a plan in there somewhere.
Something, yeah.
Okay. So you've given me the 2-minute time cue the last 5 minutes. Just want to put that out there. Let me talk real quickly about tomorrow. So tomorrow, they're going to do, it's basically voir dire. It starts, right? Is that happen in open court? Do they have a side room? Do you have any idea how they're going to do that?
I have a very good idea.
Tell us,
particularly if you're talking about voir dire. The voir dire.
Is that how we do it? That's how we say it.
That's how we say it.
That's how we say it.
And by the way, what that means, it's a French expression that means to speak the truth, where we want to be able to question jurors and get their feelings, the truth about any preconceived opinions they may bring to the courtroom. Everything's an open court. This isn't something that happens in the jury room. It isn't something that happens in the cafeteria.
But are all the jurors seeing one juror answer? All the potential jurors see the answers of the other? And does that matter? Maybe that doesn't matter.
No, the initial stage in terms of qualifying people to bring back for individual jury selection is in larger numbers.
Right.
That's where hands go up. By the way, does anybody have a prepaid cruise to Barbados? Yeah, I do. All right.
And they did that kind of thing today.
They did.
But I'm saying when these 30 whatever people come back tomorrow, are they going to pull one person out and question them right in the middle of the courtroom?
Absolutely. As they narrow the panel and people become qualified for individual jury selection, you will see them in the witness box take an oath to tell the truth, and they will be examined for 30 minutes aside on whether or not they can set aside any preconceived notions and render a verdict based solely on the law and the evidence they hear in open
And the
court.
other potential jurors, though, they're the audience?
No, the individual voir dire, the whole point of it is that,
Separated.
right. Individual voir dire is exactly what it means. They're going to be out in the hallway or in an anteroom or somewhere like that, so that they're not tainted by everybody else's answers during the individual part of the jury selection, guys.
Perfect. Hopefully we're in there some way to kind of relay it back to the audience tomorrow.
We will get the information we promised. Rowan Belugan, great reporter, thank you very much. Brian Weiss, legal analyst for KPRC2, got it all out. And I'm Joel Eisenbaum. Thanks so much for joining us. We're just getting started. We're going to be doing something in some form or fashion every day this trial is going on.